the Senate assembled, that thou would direct and prosper all their advancement for the good of thy church, the welfare of thy people, and the safety of our country. Through Jesus Christ our Lord. Amen. And let us say together the Lord's Prayer. Our Father, who art in heaven, hallowed be thy name. Thy kingdom come. Thy will be done on earth as it is in heaven. Give us this day our daily bread, and forgive us our trespasses, as we forgive them that trespass against us. And lead us not into temptation, but deliver us from evil. For thine is the kingdom, the power, and the glory, forever and ever. Amen. And may the grace of our Lord and Savior Jesus Christ, and the love of God, and the fellowship of the Holy Spirit be upon us now and forevermore. Amen.
Messages from Her Excellency the Governor General. Announcements by Your Honor.
Message from the Honourable the House of Assembly to the Honourable the Senate. The message reads as follows. The Honourable the House of Assembly has the honour to inform the Honourable the Senate that at its meeting on Friday the 26th of October 2018, 1. The Honourable House of Assembly agreed to and concurred in the amendments made by the Honourable the Senate on the 24th of October 2018 to the Debt Holder Approval of Debt Restructuring Bill 2018 and the Road Traffic Amendment Bill 2018. The Honourable the House of Assembly disagreed with the Honourable the Senate in the amendment to the National Insurance and Social Security Amendment and Validation Bill 2018 made by the Honourable the Senate on the 24th of October 2018 and amended the bill by leaving out the words substituted and reinstated the words appearing in the original bill for the following reasons. From the 1st of January 2006, the contributions payable by self-employed persons under Section 13 of the National Insurance and Social Security Act, Chapter 47, was 15.5%. The training levy of 0.5% payable under the Occupational Training Act, Chapter 42, and the Catastrophe Fund levy of 0.1% payable under the Catastrophe Fund Act, Chapter 39D, must not be included under the National Insurance Self-Employed Persons Regulations 1970, as it would inaccurately inflate the amount that should be paid by persons under those regulations. And the Honourable the House of Assembly transmits the amended bill to the Honourable the Senate, inviting concurrence in the amendment to the bill. That message is dated the 6th day of November 2018 and is signed by the Deputy Speaker. continuing on the yes. We have next on the agenda the yes. The language of Parliament. There's a stranger at the table, and we need to welcome her, and even more than that, embrace her. She's a newly appointed Deputy Clerk of Parliament. Her name, as you might have learned from today's paper, if you had not learned it before, is Beverly Gibbons. And we want to congratulate her on her appointment and wish her well in this tour of duty as Deputy Clerk of Parliament. She is no stranger to the corridors of power, as it were. She, in her time, has worked with former Prime Minister Arthur as well as the current Prime Minister. And to that extent, they say she's not unfamiliar with the corridors of Parliament. But this is a new area of operations, perhaps an extension and enlargement of the ones to which you have become accustomed. And we are sure that with your unfailing good manners and graciousness, combined with your hard work and efficiency, you will soon settle down well and serve with distinction. We welcome you and we wish you well.
Mr. President, I would also like to join you in welcoming Ms. Gibbons, our new Deputy Clerk. Indeed, I wish her well, I wish her all success. And I want to note that in the history of Barbados' parliamentary system, she's indeed the first female to hold the post of Deputy Clerk, or indeed Clerk. And I want to welcome her and congratulate her.
Senator Frank.
President, I also want to join as the leader of government business to welcome the new Deputy Clerk. And I must admit, right now up front, she's known to me. I've admired her for a long time. And I know of her work and I know of her capabilities. And I am sure that the work of the Senate will be all the better for her being here. And I want to compliment her on her appointment. I did so personally earlier, and I now want to do so officially. Thank you very much, Mr. President. Welcome.
Forgive his absence, but I think he's serving an important interest, and to that extent, we wish him well and understand his absence. Is there someone else that did write or call? I didn't think that there was anyone else from whom I heard asking that excuses be made for their absence. I'm not being heard at the journalist's desk.
Too far from the mic.
Yes. I'm being told that I was perhaps sitting too far from the mic. You're hearing me now? Yes, thanks. I'm being heard. What's the next item?
Presentation of petitions, presentation of papers. Report from select committees. Questions to ministers. Request for leave to move the adjournment of the Senate on matters of urgent public importance. Statements by ministers or parliamentary secretaries. Personal explanations. Motions relating to the business or sitting of the Senate and moved by a minister.
Mr. President, I beg to move the suspension of Standing Order 45-2 out of an abundance of caution, so if it might become possible to deal with the resolution regarding the national insurance.
Question is that there be suspension of Standing Order 45-2 for the balance of the day's proceedings. All honourable members in favour, please say aye. Those against, please say no. I think the ayes have it.
Introduction of bills.
President, I beg to give notice a resolution to approve in accordance with Section 5 of the Crown Lands Vesting and Disposal Act, Cap 225, the vesting in the National Housing Corporation of the parcel of land, the property of the Crown, situated at Chancery Lane in the parish of Christchurch in this island for the public purpose of housing development. I also beg to give notice of a resolution to seek the concurrence of the Honourable the Senate in the amendment made by the House of Assembly to the National Insurance and Social Security Amendment and Validation Bill 2018.
Public business. Order number 1, in the name of the Honourable Leader of the Senate, to move the second reading of the Offences Against a Person Amendment Bill 2018.
Thank you, Mr. President. Before I commence this debate, I first want to beg your indulgence to allow this to be a cognate debate, including items 1, 2, 3, 4, and 5 on the order paper for today. The reason being that I'm sure that all members recognize the interconnectivity of these items, and I would propose that it be done as a cognate debate.
Cognate bills, and all honourable members in favour, please say aye. Those against, please say no. I think the ayes have it. Please proceed, sir.
Thank you, Mr. President. Mr. President, historically and all over the world for several hundred years, the death penalty has existed for murder and other crimes. This year in the 16th and 17th century, death penalty was carried out in a number of ways. Certainly in France, it was the guillotine, and in the British colonies, hanging was the preferred option. However, over the years, certainly starting with the European philosophers in the 18th and 19th centuries, and later on the church, arguments were put forward in terms of the death penalty and that it was a cruel and inhumane way to deal with people. And over the centuries, this discussion has ensued. In more modern times, with the involvement of multilateral agencies like the UN Human Rights Council, and indeed the Inter-American Commission on Human Rights and the Inter-American Court on Human Rights. Additional pressure, so to speak, has come to countries, especially countries like Barbados, which have signed on to all of these conventions on human rights, and certainly we believe in the preservation of human rights. The issue has become more or less on the front burner, and countries had been advised, cajoled into moving away from the death penalty, and certainly moving away from the mandatory death penalty. This whole matter has stimulated legal, philosophical, and moral arguments. Persons argue, how can you tell a society that the killing of someone is not to be done by killing someone? How do you advise people that it's not good to murder another person by the society allowing persons to be executed? And of course, there are those who take the view that indeed this death penalty is indeed a useful deterrent, and indeed a deterrent. And again, the jury is out on this in terms of the objective analysis to prove that this is indeed the case. I mentioned the Inter-American Commission on Human Rights and the Inter-American Court on Human Rights. And in recent years, this entity has found Barbados' use of the mandatory death penalty to be in violation to certain conventions on human rights, which this country has signed on to over years. And we have been advised repeatedly in terms of amendments to our laws in terms of the mandatory death sentence. While we have been doing this, our brothers and sisters in CARICOM have been moving forward, so to speak, in the removal of the mandatory death sentence. I believe it is only Barbados and Trinidad and Tobago which still have this on their statute books. Mr. Chairman, if today's bill is passed in this honorable chamber, it will not mean that the death penalty would have been abolished in Barbados. Indeed, I know that honorable members might speak about that today and the need for that, but certainly this plan is not for that to be debated, certainly on my mind today. There will be time in a different place, in a different setting for that. And certainly, the manifesto of the Barbados Labour Party speaks to the fact that if we are looking at things like the abolition of the death penalty, it will not be decided by 30 persons in the other place or 21 in here, but certainly there will be a need for a referendum for the public to have their say. But if this bill is passed today, Mr. President, judges will no longer be bound, so to speak. They will be allowed some discretion to determine in any particular case whether the nature of that case or the circumstances of the offense indeed would have merited and warranted the imposition of a death penalty. As it stands now, they are more or less pigeonholed in terms of our laws. Obviously, the circumstances of murder and manslaughter differ. And I've heard recently of a case where someone was provoked into a fight, was attacked, used a knife was thrown on them. They grabbed the knife and resulted in the death of the person who had attacked them. And indeed, because of certain evidence, this person is being charged for murder. And these circumstances need to be taken into account when deliberating in these matters and making decisions. This has been discussed in Barbados for years, and certainly both political parties at the highest level in terms of the attorney generals, and I can think of at least 4 attorneys generals, who over the past 20 years or so have defended the right of Barbados to have the mandatory death sentence maintained on the statute books. But, Mr. President, the life and world is not static. And certainly the feelings of Barbadians, and indeed those in the legal profession, seems to be moving more and more in terms of certainly the removal of the mandatory death sentence, more towards eventually looking at the possible removal of the death penalty. Mr. President, over the years, we have resorted to the British Privy Council in terms of our final court of appeal for these criminal matters. And it was 14 years ago, in 2004, that the Judicial Committee of the Privy Council, in the case of Boyce and Joseph, that they ruled in terms of Barbados that a mandatory death sentence was cruel, was inhuman punishment, but they considered themselves obliged to uphold the penalty because of a specific savings clause in the Barbados Constitution, which made the sentence, the original sentence, immune from challenge. So we've had this going back to 2004. In 2005, Barbados adopted the Caribbean Code of Justice as our most superior court to hear these matters. And we are here in effect today because of the consolidated case of Jabari Sensimania Nervis and Dwayne Omar Severin versus the Queen. And these individuals will certainly go down in history in terms of Barbados' penal code and in terms of the statutes as it relates to murders. These two gentlemen, were convicted of murders which were committed in 2006 and 2009, respectively, were subsequently tried, and both of them were convicted and sentenced to murder. They subsequently appealed to the Court of Appeal here, and their appeals were dismissed. The then president of the court, now Mr. President, I must apologize for not speaking to it before, but the current Governor General then stated, and I quote, and given the judgment, and it is ironic what she stated, that Parliament would have to make the necessary changes to Section 2 of the Offence Against the Persons Act if the death penalty were to be placed at the discretion of sentencing judges. Mr. President, I repeat, she said that Parliament would have to make the necessary changes to Section 2 of the Offences Against the Persons Act if the death penalty were to be placed at the discretion of the sentencing judges, and as a result, the appeal could not be appealed. And Mr. President, I think all honourable members have been well informed of what is being debated today and would have certainly realized that this is the same amendment to Section 2 which we are trying to do in this bill. Mr. President, the Constitution of Barbados guarantees certain fundamental rights. And in Chapter 3, Section 11, I believe, speaks to the protection of fundamental rights and freedoms of the individual. And it goes on to say that whereas every person in Barbados is entitled to the fundamental rights and freedoms of the individual, that is to say, the right, whatever his race, place of origin, political opinions, color, creed, or sex, but subject to respect for the rights and freedoms of others and for the public interest to each and all of the following, namely, A, life, liberty, and security of the person. And it goes on to speak about protection of privacy and indeed at sea, protection of the law. And this is very interesting, Mr. President. This is part of our 1966 Constitution. But in that same document, at Section 26, it's called the saving clause, saving of existing law. It speaks, nothing contained in or done under the authority of any written law shall be held to be inconsistent with or in contravention of any provision of Sections 12 to 23 to the extent that the law in question, and it goes on in terms of the various subsections. And this is important, Mr. President, because the Caribbean Code of Justice has used our Constitution as the basis for their ruling in this case of these two gentlemen. It has ruled, and this was done in June this year, hence the urgency, that, and if I may quote, that a section of the Offences Against the Person Act was unconstitutional because it provided for a mandatory sentence of death. Further, it held that Section 11 of the Constitution, which gives the right to protection of the law, was enforceable, and that the mandatory death penalty breached the right as it deprived the court of the opportunity to exercise the quintessential judicial function of tailoring the punishment to fit the crime. It also felt that in these days, the saving clauses, Mr. President, should be condemned, and laws should not be calcified to reflect the colonial times, end of quotes. Felt that human rights develop and improve and people look at it differently, and that saving clauses like this one deprive citizens from benefiting from evolving fundamental rights and freedoms. Mr. President, there are currently 11 persons on death row in Barbados. As a basis of this ruling, they will now have to be resentenced. I'm told, because their constitutional sentences are now considered by the CCJ as being unconstitutional, and my learned legal friend on the opposition will no doubt concur with this. I'm told that there are 62 persons awaiting trial for murder and 6 for manslaughter. If we were not to pass this bill today, it would put our judicial system in a quandary. You would have 68 persons who are there to have trials done. And at the back of that, at the end of it all, judges will know that they are confined by the mandatory death sentence. But if they convict someone and sentence it, at the end of the day, they know that the CCJ has already ruled that that is unconstitutional. So I believe, Mr. President, we are in a bind. We have survived over the years, as I said. We have discussed and we have utilized our mandatory death penalty. We have debated it. We have made promises to amend it. We've made promises to the UN. We've made promises, as I said, in terms of the Inter-American Court of Justice and Commission on Justice. But I think our reckoning time has now come. The CCJ has, with this ruling, told us, in effect, that what you're doing is unconstitutional and you cannot continue doing it. As I said, only Trinidad and Tobago will remain as the country in the region that are doing this. I reiterate what I said at the beginning, that this is not about removing the death penalty per se from the statute books. I have no doubt that that discussion will ensue, if not only today, in the coming months and indeed years. I think I have my perspective, and I know I will not deny that in terms of Barbadian public, there is certainly a feeling that the death penalty should be maintained. I believe I saw a survey done by Cadres last year, which indicated, although there was a decrease in the percentage of Barbadians who supported it. I almost said it was akin, Mr. President, his criticism of the Cadres was akin to him being criticized by the legal profession or indeed the trade unions. But I wouldn't say it. But the death penalty is not being removed today. It is not. I believe also, Mr. President, and I don't believe I would be criticized for saying so, that both major political parties are ad idem in this matter. Indeed, the previous Attorney General had promised in 2014 that it would have been amended, and it was repeated in 2015 by the said Attorney General. A previous member of this Honourable Chamber had asserted, and she represented St. Andrew, at least in her mind, that it would have been amended. And so I can say that both both major political parties. And I see some of the members on the other side spread. I am not saying that they're involved in politics or with any major political party, or minor for that matter. But I also know that the opposition leader, who is represented here, is a bishop. And I have no doubt that in the 21st century, I will find a bishop, indeed a Christian bishop, who will be opposed to removal of the mandatory death sentence. So I wait with glee to garner the support of the opposition members who sit in this honorable chamber. Mr. President, there's not much to say. I expect to hear a very persuasive debate today from honorable members. I look forward to the contributions of all honorable members. I hope, and I'm almost certain, that they will more or less endorse the proposal of the government in terms of the amendments to this bill. Mr. President, I ask for the other bills to form part of a cognate bill. And again, I think all honorable members will recognize that the amendments in the 4 other bills are consequential, not necessarily to the amendment which is made me ask for in this bill. And Mr. President, with those few words, I beg to move to move the second reading of the Offences Against the Person Amendment Bill 2018.
Thank you very much, Mr. President. Again, I concur with Senator Walker, but for different reasons. But before I get into any substantive thing that I want to say, I am a bit confused by the amendments to the Offences Against the Person Act. I will defer to the legal minds in here, you, sir, and Senator Tate and Boyce. I will be guided by them, but and to some extent Senator Sands, but but I would be, oh yes, and we have another legal mind, but I don't think I'd be guided by that one. I know, no, sir, but what I want, sir, is that if you look at the amendment section 2, it says, a person who commits the offense of murder may be liable on conviction on indictment to A, suffer death, or B, imprisonment for life. It gives you 2 options. But then if you go on to subsection 6, it says where the court in sentencing a person convicted of a murder does not impose the sentence of imprisonment for life, the court shall impose a term of imprisonment having regard to the guidelines settled in sections 39 and 41 of the Penal System Reform Act. But that seems to be a conflict in my mind. I don't know if there's anybody else's, because it says the court only has the power to do 2 penalties, death or imprisonment for life. But later on you're saying, but if you don't impose them, you can impose something else. You can't get both ways. So I don't know if that needs to be amended in any way or to be clarified in any way, because, as I said, I will be guided by the legal minds. But to my mind, it's a bit conflicting. So my understanding is that at section 2, it only gives you 2 options. It says these are the 2 options that the court has, and then it gives you a third option somewhere down the road. If you don't impose these 2, you can only do 2. So this shouldn't have some provision. It should be 2 section 2(1)(a) and B, and it should be a C, so that you can then address the areas where the court can impose another penalty other than imprisonment for life, because it says that's all you can do. I don't know if I'm making sense. This is the Offences Against the Person Amendment. No. What I'm saying to you is, I'm reading this by itself. It says that the court can only impose 2 penalties for murder. but then later on it gives you an option to give a third. If you're setting out, it has options, 3 options, put the options up front. But again, I said I could be wrong, and I will go on. I just thought that it was confusing to me. Sir, at this time, I see I want to get a at this time in our development, right, in this country, violent crime is rampant. We have situations where people drive by and shoot, people walk into a shop where people playing some dominoes and shoot up the place, sometimes getting the right fella or the wrong fella, as the case may be, I don't know. And if you did not understand what is happening here, you would believe that the government is getting soft on violent crime. That is not the case. You would believe that they're going mad. You know, yes, they're going mad, but not for these reasons. All right? This came about, where we find ourselves now came about because we have a situation where government ministers like traveling. They go to these conferences and meetings and stuff, and they sign things that they don't understand what they're signing. And then when they get back to Barbados, they didn't even know that they commit this country to certain treaties that would abolish the mandatory death penalty or anything else for that matter. We do it in immigration too. We go and make a lot of sign up and then find out later on. Then the people of this country find out later that the politicians have committed us to things that they did not intend. And I suspect that this is one of them. Right? And we now have to fix it. And I would like to warn this present administration now to be careful what you're getting into, you know? When you go to these meetings and you get persuaded by these people from overseas who have agendas, you know? Come back to this country first. Don't sign up front in the heat of the moment. And then discover, oops, I did a bad thing. Or we did a thing that the people of this country, you had no mandate from the people of this country for, right? The people in Barbados, to my mind, prefer to have the death penalty available to them. Because remember the scenario that I spoke about where people run into shops or drive-by shootings? Sometimes that bullet could go stray and go in the house and kill a little child or something. So, people are outraged and incensed by these wanton acts of stupidity, criminal stupidity, and they believe that people should suffer and not only imprisonment, because after a while you come out of jail. Even if you get life does not mean that you stay in the prison until they put you in a box and send you to meet your maker. After a while, according to these guidelines that we are looking at earlier today, you can get out. The problem there is that the person that you killed all those years ago still dead. And that is one of the things that I think is operating on the minds of the average Barbadian. He got away with it already because you let him live. I know you're letting you out too. I think that is that's what we have to address. If we want to address a situation of even abolishing death penalty, and we are not doing so, Senator Walker, I know. Right? So, as I said, government is not going soft on crime. Government is now trying to fix problems that was created by previous administrations, including the previous Barbados Party administration, when we got ourselves involved in things that we shouldn't get ourselves involved in. Or we shouldn't get ourselves involved with the necessary debate around the country to determine the will of the people. The will of the people, like for instance, in this last, we gave this last administration 30 seats because the will of the people was that these people will give us prosperity. We know differently. No. So the will of the people is being frustrated at every step. Politicians go and they make all these promises, they get involved in things that they're not supposed, that they don't know what they're getting into, and we find ourselves having to avoid the scrutiny now of international agencies and international human rights courts and stuff that's pointing fingers at Barbados. And the first time, sir, that I heard about Barbados death penalty and that we have breached these rules under these international treaties, I was shocked. I think I'm pretty up to date and I listen to the news, but I didn't know that we weren't saying anything, you know. And I follow the news, I follow current affairs. But I wasn't following closely enough because we committed ourselves to certain things and frustrate the will of the people. Mind you, sir, I am not opposed to the death penalty in any way. I figure that if you go that way, you know what you were doing. You should, and you know what the consequences are before you set about on your mission. Then you suffer the consequences. So I'm supporting the death penalty. Yes, I am. But I am not supporting the way that it is being administered in Barbados, or who gets sentenced to death in Barbados. I know some people will criticize me when I say that it seems to be reserved for poor black men. Whenever you have a situation in this country where some person of another ethnic group commits or kills somebody, you can't say commit murder because murder has to be proven. No matter how heinous that crime or the circumstances of that crime, the person gets an offer of plead guilty to manslaughter. But the black, young, foolish boy doesn't benefit. And I could give examples. I think I will give a couple. Some years ago, a Caucasian man killed his son. And from my understanding of the circumstances, I read what was said in the court. And I'll tell you now, I'm an expert on weapons. For those of you who want to challenge me, I am an expert on weapons. I taught people how to use weapons and use them safely. I was doing it from the time I was a very young man. And I haven't forgotten how, or rather, I'm still able to use them and to clean them and do all that thing properly. So the scenario that was given to the court, that the court accepted and the DPP accepted, was completely bogus. The only way it could have happened is if the assailant had three hands. Because one would be on the butt, one would be on the barrel to lift up the clips, and the other one has to be in front of the barrel. So you have to have at least three hands. It was entirely impossible to happen that way. But we accepted, and he got community service. Community service for killing your own child. In circumstances that nobody knows what transpired other than who was there. Because the scenario, if you know anything about the weapon that was used, it can't happen that way. I know it well. Couldn't happen. But he got away with it. And then he didn't even complete the community service. But nothing happened. I know, the thing that really bothers me is that he got community service, and the guy who stole $57 in cheese spent a month in jail. He killed a fella, you know. And he get community service. And a youngster, well, not quite young, he was almost my age, stole $57 in cheese, and he spent a month in jail. So that's the kind of problems I have, you know. These things are not sheriff ready. If we had another instance where a guy from, an Indo Guyanese guy, he had a problem with his employer. He come to some blows or something, and he ended up in the hospital. And he vowed that he will take revenge. And he came back with murderous vengeance and went to the employer's house and killed his stepdaughter. put her on some cans to stand up and put a rope around her neck and tell her if she's drop off like you're going dead. And you know, it was cold, calculated murder. And you know, we had at the time also a Guyanese DPP who took a plea of guilty of manslaughter or something like that. Manslaughter for deliberately setting a 16-year-old child on some paint skillets to stand up and balance with a rope on her neck. But the rope hanging on her neck, she's hanging from a rafter. And he got away with it. You see, so you had to have the, so neither of these were poor black people. The only time black people get away with it, with murder, is if they have connections. I will say no more other than to say that you can get away with murder if your sibling is a judge, but I'll go no further into that case. You know, we have instances in Barbados where people have committed murder and you allow them to languish in jail, hoping that the country forgets. And then after a while they say, you know, the police are not bringing the case. The police are told not to bring the case. And then after a while they get bail, and then you don't hear nothing about these crimes after that. You know, I am concerned about that. So if I have an opposition to the death penalty, it is because it isn't being treated, or the people are not treated fairly. It is not applied as, you know, you have situations where one law for the means and the other for the persons, that kind of thing, but I leave that for the priest. The people, if you commit murder, everybody should be treated the same way if the circumstances are the same. You do not have a situation where, because of the color of your skin or the connections that you have to either people in the hierarchy, you know, because sometimes, you know, even simple little things like, I don't know if you don't murder now, you know, a guy ran into my car, almost killed me, and because he had a police relative, the case never came to court, you know. Never came. So this country is unfair, you know. It treats the majority citizens of this country do not benefit from the law as intended. You have to have special circumstances. That's what I'm concerned about. I want next to deal, sir, with the Caribbean Court of Justice. When that court was first being touted, I was all for it, you know. I think, but more I hear, and the more disillusioned I become. Senator Walcott said, you know, that their rule that the mandatory death penalty was unconstitutional because of something, and I remember them saying that Section 26 of the Constitution, the Savings Law Clause, was intended to be a transitional provision. That is the first time ever that I heard that. And I wondered where the court came up with that kind of novel legal reasoning to come to the conclusion that they want to come to. Right? If that were a transitional provision, the Constitution itself would have said so. I've seen where, even in the Housing Act, where the employees of the National Housing Corporation are covered under the Pensions Act for public servants as a transitional provision. It said so. Mind you, that's almost 50 years old, but the provision is still transitional. But that said it was intended. This Constitution never made such a thing, you know. Never made any such reference to any transitional provision. That is the law. They might not like it. But we have a Caribbean Court of Justice that has made itself into a legislating court. It is starting to legislate for Barbados. And I am worried about that. As much as I don't like it, we have a legislature with 29 people on one side, and the lower house, and of course we know how the Senate is configured. That is our job. They don't rule something unconstitutional because they don't like it. They can make suggestions that it should be changed. But the rule, it is not unconstitutional. But I can't say it is not unconstitutional because they have ruled it to be unconstitutional, and because they are the highest court in this land, then it is. But I would like to understand their reasoning. Because I am getting tired with them and their thing, you know. They made a decision some years ago in the Winton Campbell case, where without hearing any argument, concurred that a person who was 37 years old should be getting a pension, without understanding the intent of the Pensions Act. Then listen to arguments, they just come out and do things without research. And I have a problem with that. They are shoddy. And I'm not surprised that Antigua and Grenada rejected them, you know, because they can see what is happening on the ground. They can see the court being, I don't know, I don't know if it's a political.
Senator, you've been very condemnatory of the whole justice system here, the prosecution division, the judges. Now you've gone to the CCJ. Often, before you get to speak a word, you have to provide written submissions. And in many cases, on the basis of the written submissions, a decision is made. So by the time you get up, you don't have to say a word. On the basis of the written submissions, which is your case, we have given great thought to them, and we rule as follows. So the notion that a word was not said, and yet they ruled, I don't think you're being fair to the CCJ and to the justice system generally. I have been involved in some of the matters in which you speak, and I am appalled of the fact that you clearly have no detailed knowledge of events, and yet you're speaking with great authority and with serious condemnation of the institutions which protect us and which do a great job.
Sir, I know that you were involved in a few of the cases I speak about, but with all due respect to you, sir, I don't think we got this country got justice in many of them. The people would have gotten away with murder because you were an excellent defense attorney, but the shoddy work that passed through that allowed you to win should not have shouldn't happen. I'm an expert on weapons. I know the cases. I know them well. I know there might be weapons that you can tell me. And I'm saying to you, sir, they might have convinced you, but they will never convince me. You know? As I was saying, though, because even if, and I'm saying I can tell you about the detailed knowledge that I don't have about the written submission stuff. The case that I'm speaking about with the CCJ, there were no written submissions on that point. The point I was making. What the court said, the Court of Appeal said something and they concurred with it. Then no agreement. It says the Solicitor General at the point in the Winton Campbell case has said in the court, and they went along with it, but something that the Solicitor General said without examining the point. And at that point now, sir, is being used in this country today to disadvantage civil servants, because right now we are sending home appointed civil servants and giving them and not giving them a cent. Well, the council not giving them a cent. They're only giving them a month's pay, notice, and then their pensions, they're taking them and compensating them with their pensions rather than giving them compensation for their year's service. That the CCJ and their bungling has done that.
Senator, I'm disinclined to interrupt you, but you're straying into paths of greater relevance. Remember what you're discussing.
So with all due respect again, sir, you pointed out that I was in error, and I'm showing you where my error was, but I will go on. I was talking about my support for the death penalty and why I do not like how it is applied. But I support the death penalty, by all means, I support the death penalty, and I think we should even go further. I really feel that the death penalty should be applied for other crimes, like rape, and rape of little children, particularly rape of little children. No, I ain't going to rape my sir. Don't worry about it. So I don't worry about it. I feel, sir, that the death penalty should be applied for other crimes, and I said rape, particularly the rape of children. You know, I believe that we have to re-examine our laws, but when we do that and see what the people want, I can assure you, sir, that there are a lot of people out there who would rather see the end of a fellow who raping little children than having walking about the place and then come back sometime later and do it again. If not murder, castration, and I don't mean chemical castration. I'm a fellow, I like the razor. You know? But while we're at it, sir, while we are amending these laws and we are thinking about locking up people for these different crimes and stuff, there's another problem that I have. And I see a lot of, again, young, poor black men going to jail because they couldn't afford an attorney. They didn't have one. I do not feel that anybody in Barbados should have to face the court without legal counsel unless he doesn't want legal counsel when his life or liberty is at stake. Too important. We have enough lawyers in Barbados. A lot of them are under work, where the government could establish a department to, like what the United States have a public defenders department. Legal aid does not cover.
Senator, you sure that you have refreshed yourself on the provisions of the Legal Aid Act?
Yes, sir, I have. When you go in the magistrate's court, unless there's some technical points and stuff, you don't get legal aid. A lot of people go before legal aid is for specific crimes, and if divorce and stuff like that, you get legal aid. But when you have the fellow out there who fights in the bystand and something, not legal aid. If you are going to court and you could be jailed, the offense for which you've committed, if you can go to jail, you should have the benefit of legal counsel. That's all I'm saying, if you want it. We have enough lawyers in this country where the government can set up a department of, the Americans call it again, I just call it public defenders, where cases are assigned to public defenders, and those people, sometimes I went to court one day and I saw a fellow who was a big bad fellow on the street. And when the magistrate started to talk, he started to cry, you know. He ain't a big bad fellow anymore. You see, he's unfamiliar with that territory. He's a bad fellow on the street, big tough man. But when they get in court, they want the money, and they can't defend themselves. Trust me, and I've actually seen one fellow where a bad spot start to develop, and the pants and get bigger and bigger. And he was a big bad man in the court. And as a result, they go to jail sometimes in instances where if they had an attorney, the attorney could have made some missions on there, and they end up with a lighter sentence, or they might be convicted at all. But they're tied down. They can't develop an argument. They don't know the law. And you have experienced policemen, or if they are being prosecuted by DPP, you have experienced prosecutors prosecuting them, and the only thing they know about law is how to break it. And then, you can't just lock them up. You know, I believe if you're going to lock up a fella, he should have a fair fighting. He should have a fighting chance. And most of the people who end up in front of the magistrates don't get a fighting chance. And a lot of people get sentenced, or not sentenced, but remanded to prison for the most minor, simplistic little things, because the magistrate can. And you were asking me to refresh myself on the the law, but I'm surprised so that sometimes the magistrates seem not to have refreshed themselves on the conditions on which bail should be granted, and they refuse bail on whims. You know? Right? So, Mr. Speaker, Mr. President, I just want, I'm going to close now, but I want to and I will support these amendments, right? Because right now, I don't like to see people get sentenced for mandatory, because sometimes a mandatory death sentence, because sometimes in the heat of something happens, and some person dies as a result. You might not even intend to kill, but sometimes because the jury don't see it your way, they might find you guilty of murder, when in fact it was a situation where it could have been manslaughter. So I would prefer to see the judges have a wider discretion, but what I don't like, sir, is the Caribbean Court of Justice and international bodies telling us in Barbados how we should run our place. They don't tell the United States, The United States kill people by lethal injection, and the people ball through the execution, cruel and unusual punishment, and nobody tells them anything. But little Barbados has to be the whipping boy for everybody, and because sometimes we want their aid, they will only tell us how to run this place. This is ours. We are independent. I would like to see these things change, but not at the insistence of people who want to bully us into taking these steps. We've reached that point. I don't think we can do better now. But I just want it on the record that I am opposed to how we got here. I'm obliged to you, Mr. President.
Thank you, Mr. President. So I rise not to spend much time. I would not certainly be as long as Senator Franklin, but I want to upfront, sir, support this move of the government to have the passage of these bills before the House. I fully endorse the repeal, sir, of the mandatory death sentence that is currently in place for all persons who are currently convicted of murder in our island. I understand from a little bit of research that I would have done that this repeal was actually on the minds of the last administration since 2011. And I'm not sure why it would not have been passed during that time, what would have hindered them to get the move on in terms of having such a repeal done. But I'm very grateful to our current government for seeing it fit to take this action of having these bills passed. I'm hoping that they will be passed today in terms of enabling the fact that we do no longer want the mandatory death sentence to be in place. You may wonder, sir, why I'm so pleased that such bills are before the House at this time. But as I would have mentioned from my last contribution here within the House, that indeed it is really from a conviction in my faith that I always tend to seek to speak when I come in this honorable chamber. And it is because of my Christian faith and conviction that I am so moved to, of course, support such a bill that takes a good step forward in ensuring that persons are not suffering as they may not have committed certain crimes or a certain level of crime. So with the passage of these bills, it was noted by the government that we will now be moving our country more in line with the position held by the CCJ as declaring the mandatory death penalty as being unconstitutional, that not everyone convicted of murder deserve an automatic death sentence. These bills will also, in my opinion, enable us as an island to move from being among those states who retain death penalty for every murder or ordinary crimes and shift it across to being among those who use capital punishment for exceptional or extreme circumstances of murder. Certainly, I believe, Mr. President, that it is a move, it is a step in the right direction and I say a step because I still believe that there are further steps to be taken, unlike what I would have been hearing from Senator Franklin earlier and maybe even from Senator Walcott. But I do recall there is a passage that was reflected on Sunday where Jesus would have made the comment that, we are not far from the kingdom of God. Which means indeed that we are taking at least a step closer to what I believe, and for my conviction, that we are getting closer to what indeed I believe God will really desire us to have in this world and even in our island. And I know that this debate is not necessarily about the abolition of the death sentence, but of course it is part of it that of course indicates that anyone who commits the offense of murder may be liable on conviction on the indictment to suffer death. So it to some extent indirectly still addresses the fact that we are still calling for capital punishment, the death sentence. And so let me say up front that I am opposed. I'm not a believer, I'm not a supporter of capital punishment in any form, for any reason, or account of murder. Many a time I would have robust discussions even within my own congregational family, particularly of two members who of course they themselves support the death penalty. They would often make reference to the portion of scripture from Genesis 9 where it says that if a man sheds blood, by man his own blood shall be shed, which were words given to Noah where he said by God. But no, I'm always taken back to the earlier story of Cain and Abel, and Cain murdering Abel. I know again, yes, it is not about a debate on the death penalty per se fully, but in that story I'm reflected on the fact that God protected Cain after he murdered his own brother, out of jealousy, out of whatever the situation may have been. But more so, when I go to the New Testament, I am mindful of Jesus' own response when he encounters such situations that would call for the death penalty. Where, for example, we have the very familiar story of the adulterous woman coming before our Lord. Again, it was by law that once you commit adultery, you should be stoned to death. But yet our Lord turns and says, "He who is without sin, cast the first stone." But then I go further and reflect on Jesus' own crucifixion. He did nothing to deserve death. They were all the persons who can very well be considered the criminals who were calling and who would have crucified him on that cross. But yet from the cross, he says, forgive them. Yes, for they know not what they do. And it's because of this where I see that our God at the beginning of near creation, where he has Cain being saved, he recognized that even though Cain would have committed that serious crime of killing his own brother, that God still saw the value of Cain's life. And that Jesus also saw the value of those who were committing a heinous crime of crucifying him, of killing him without a cause. But yet, Jesus showed mercy. Jesus showed the possibility that these persons can change or be penitent or be rehabilitated. And so, sir, I know I may have another occasion a little later on, as Senator Walker is saying, that it may very well come again before this honorable house that we may have a fuller debate on the abolition or not abolishing the capital punishment. But I just want to say as I close that I'm in support of this measure, even although for me it is just a small step. I still see it as a very important step that we are taking, and so I will support this bill, but I do hope, for my own conviction, and I may be a lonesome voice crying in the wilderness, but that indeed, that I hope that we will one day, coming soon, move towards possibly the abolition of capital punishment, recognizing that because I may not have valued someone's life does not mean that my life doesn't still have value. And there's a possibility of discovering that value and the change of life, even if it is through life imprisonment. I'm obliged to you, sir.
Next recognized Senator San.
Good afternoon, honorable comrades, honorable senators. Now, a few weeks ago, there was some great consternation amongst the Barbadian people in respect to the issue of the mandatory death sentence. Persons approached me, engaged me in conversation, and basically expressed mixed feelings about it. And it was at that time that I recognized that there were a few Barbadians who simply did not understand what the actual bills that we were proposing were actually about. They were of the view that the focus of the bills was about the abolition of the death penalty. I want to categorically state this morning from the outset that these bills in this Honourable Senate are not focused on the abolition of the death penalty. Our focus this morning is simply on the mandatory nature in which the death penalty is imposed once a person is convicted for murder. The death penalty shall remain on our statute books and shall remain enforceable. It is only the mandatory imposition that we are focusing on. As it currently stands, once a person has been convicted for murder, the judge does not have the power to consider the circumstances of the crime and use his discretion to determine whether the convicted murderer's actions should be punishable by death or if by a term of imprisonment. So in other words, once a person has committed murder, regardless of what the circumstances may have been, regardless of what would have caused him to commit the offense, regardless of any of the mitigating or aggravating factors in the commission of the offense, the judge has no choice but to sentence him to death. This is our country's ritualistic way of dealing with persons who are convicted of murder. The current system exists on our statute books in a 21st century Barbados. The proposed amendment bills seek to simply change this system. These amendment bills will remove, as I said, the mandatory nature of imposing the death penalties on the individuals who are convicted of murder. Now, the removal of the mandatory death penalty is not an issue which has recently surfaced. This issue has a long history, both in Barbados and other Commonwealth countries. So before I can even delve into the proposed amendment bills, I must first provide the context so that ordinary Barbadian people may learn and understand the history surrounding this issue and consequently be placed in a position that they can appreciate the reasons and the purpose for the bills for which we're proposing this morning. In 2004, the constitutionality of the mandatory death penalty was challenged in the case of Lennox Boyce and Jeffrey Joseph against the Queen. This case was heard before the Judicial Committee of the Privy Council, which Barbados at the point in time, and which was the highest appellate court in Barbados at the point in time. 9 judges from the Privy Council adjudicated this matter, and in a majority 5. The case of Lennox Boyce and Jeffrey Joseph against the Queen. As I was stating, 9 judges would have adjudicated this matter, and in a 5-4 majority, the judges determined that the mandatory death penalty constituted inhumane and degrading treatment, which would naturally be in contravention of our fundamental rights and freedoms that are enshrined within our Constitution. But due to the existence of a savings clause in our Constitution, the mandatory death penalty was protected and consequently could not be declared as unconstitutional. So what is this savings clause that protects and reinforces the legitimacy of laws, even though these laws may arguably be in contravention of our fundamental rights and freedoms? This savings clause may be found at section 26 of our Constitution. Now, I won't go through it verbatim, so I'll just give you an idea to what it basically states. The section 26 of the Constitution basically states that any law enacted before November the 30th, 1966, and has continued to be a part of our law since that date, will not be held to be inconsistent or in contravention of sections 12 to 23 of the Constitution, which deals with the protection of the fundamental rights and freedoms of individuals. So in other words, if the law existed prior to the Constitution and continued to be enforced after the Constitution was enacted, the law, regardless of whether or not it was infringing upon the constitutional rights and freedoms of individuals, could not be invalidated and must be upheld based on the Constitution. Now, what this meant is that the death penalty, the mandatory nature of the death penalty, would remain in force until Parliament made the necessary changes to the law. By 2010, Parliament still had not made any changes to the legislation in respect of the mandatory death penalty, despite the Privy Council would have highlighted some of the absurdities in relation to our Constitution, and the constitutional issues that were present. Nonetheless, Barbadian cases continued to push the envelope and challenge the constitutionality of the mandatory death penalty. Between 2004 and 2010, 2 Barbadian cases, after exhausting all of the legal channels, applied to the Inter-American Court for Human Rights to challenge the mandatory imposition of the death penalty, amongst other things. In both of these Barbadian cases, the court unanimously determined that Barbados was in violation of Articles 4, subsect 1, which deals with the prohibition of arbitrary deprivation of life, and Section 4, subsect 2, the death penalty limitations. In the judgment of these 2 cases, the Inter-American Court for Human Rights made some profound statements and observations in respect of our law, and I want to highlight these points. The court noted capital punishment was compatible with the American Convention on Human Rights. However, the death penalty should be limited and strictly reserved for only the most heinous of crimes. 2, Barbados' current system failed to differentiate between intentional killings punishable by death and intentional killings not punishable by death based on the particular circumstances of the crime. 3, Barbados' mechanical application of the sentence to all murder cases was an arbitrary deprivation of life and hence a violation of Articles 4, the right to life of the Convention. And fourthly, that the sentencing must be individualized to account for the particular characteristics of the crime, and that the imposition of the death penalty must be subject to procedural guarantees. So essentially, the Inter-American Court for Human Rights told Barbados in no uncertain terms that that murder should not automatically be punishable by death. A court should have the opportunity and flexibility to use their discretion in determining the appropriate sentence which should be considered, which should be imposed, taking into consideration the mitigating as well as the aggravating factors of the specific case. Because the reality is that each case will turn on their facts and each case will have different circumstances. So each case should be treated differently. The law should not treat each case, regardless of the circumstances, with the ultimate consequence of death. Now, in the other place, Minister Abrams would have given an example of how, in its current form, this law is applied absurdly. He indicated that he had a client who would have found a weapon in an area in Barbados and proceeded to attempt to sell that firearm. In the process of trying to sell the firearm, individuals got wind of that and attempted to take the firearm from him. And in that struggle, the firearm went off and one of the individuals died. There were 2 persons who attempted to take the firearm from this one person. The surviving person indicated in the statement that they intended to steal the firearm from him, and in the melee, the gun went off. Notwithstanding that this gentleman never intended to go and kill anyone, a death occurred in the circumstances. And this gentleman was charged for murder. He was charged for murder. Now, the law in the current form simply suggests that if it's a death, the automatic conviction, if he was convicted and this case had taken its natural course, he would be condemned to death. Now, clearly, on those facts, that is unfortunate. In my view, that is a miscarriage of justice, because it is clear that that man should have been granted the opportunity of the court having the right to take into consideration the circumstances of his case before making a determination on his sentence. Unfortunately for that man, he would have taken his life, so it never ran the natural course of justice, and we would never know what the outcome would have been with that matter. But as long as this law is on our books, it is possible that that could have been the ultimate consequence. Now, the Inter-American Court for Human Rights judgment in respect of the 2 Barbadian cases as I highlighted earlier was not novel by an international perspective, by international standards. The mandatory death penalty for murder has been in rapid retreat worldwide. Prior to these rulings by the Inter-American Court for Human Rights, there were a number of countries that were making strides towards removing and abolishing the mandatory nature of their death penalties. So I will list a few. In 1970, the United States of America, they indicated that their mandatory death penalty for murder was declared unconstitutional. The African countries of Malawi, Uganda, and Kenya have all found the mandatory death penalty to be unconstitutional and have replaced their laws with discretionary systems. Regionally, in 1992, Jamaica was the first English-speaking Caribbean country to enact restrictions on the mandatory death penalty through the Offenses Against the Person Amendment Act. Of the Caribbean countries, only Barbados and Trinidad continue to sentence people to death based on a mandatory death penalty scheme. The Inter-American Court for Human Rights recommended that Barbados adopt legislative or other measures to ensure that the imposition of death penalty did not contravene the American Convention on Human Rights, and that the mandatory nature of the death penalty should be abolished. 6 years after these recommendations were made by the court, Barbados still has not made the necessary changes. We continue to sentence people to death to this day. So basically speaking, we're currently in contravention with the American Convention on Human Rights, which we are signed to. Now, as a result of Barbados' failure to comply, in September 2015, the Inter-American Court held a meeting, a compliance meeting, wherein they indicated to Barbados their confusion as to why we had yet to comply with their order, which is the removal of the mandatory death penalty and the implication of measures for sentencing. Notwithstanding the criticism by the Inter-American Court of Human Rights, Barbados remained non-compliant for a further 9 years after the decision was made. In 2018, the issue of the mandatory imposition of the death penalty was finally settled by the Caribbean Court of Justice. After 15 long years of this issue being addressed in domestic and international tribunals and courts, the CCJ declared that the mandatory death penalty in Barbados was unconstitutional and should be struck down. The CCJ's decision was in compliance and in line with the decision by the earlier ruling of the Inter-American Court for Human Rights. They both shared the view that the mandatory death penalty was absurd and in contravention of the fundamental rights and freedoms of our people. This long historical context illustrates that many Commonwealth countries have been making strides towards removing the mandatory nature of the death penalty. And reforming these archaic laws must be at the forefront of this government. We have to become compliant with the modern views of the world. Barbados cannot be any exception to this way of thinking. Lord Birkenhead, in his wisdom, aptly said, "Times have changed. Human rights values set higher standards today. The common endeavor to rid the world of man's inhumanity to man has not ceased. Conduct once tolerated is no longer acceptable. Murder can be committed in all manner of circumstances. In some, the death penalty will be plainly excessive and disproportionate." In order for this country to evolve and reach its potential, we need to review and amend all of these archaic laws that are inconsistent with our contemporary perspectives. We should not be guided by laws which were born out of our colonial past. The decision by the Caribbean Court of Justice has made it abundantly clear. Our constitutional rights and freedoms must always be protected. So Parliament must pass legislation to alter the law so as to remove the mandatory death penalty as it creates and infringes on the constitutional rights of our people. And that is exactly what this Barbadian government intends to do. These bills relate to the removal of the mandatory death penalty in Barbados as directed by the judgments in the Inter-American Court of Human Rights and the CCJ. The Offences Against the Persons Amendment Bill for 2018 will simply remove the mandatory death penalty from the statute books and establish a discretionary death penalty, which will allow judges to have the option to sentence convicted persons to death under certain circumstances, or to life imprisonment with the possibility for parole. As it currently stands, there are approximately 11 to 13 people who are currently on death row in Barbados. This bill will now make provisions for persons to be resentenced under the new guidelines, as their original sentences would now be deemed to be unconstitutional. The Penal System Reform Amendment Bill will improve the judicial sentencing guidelines. It will provide guidance for judges on the consideration of aggravating and mitigating factors at the stage of sentencing, thereby enabling judges to pass sentences for murder that are tailored to fit the circumstances of the case on an individual basis. Now, another issue that I want to highlight to this Honourable Senate. As it currently stands, the law may arguably be trespassing on the power of a judge as it mandates the sentence for murder. The power of meting out justice should be at the sole discretion of the judiciary. So as it stands right now, there appears to be some form of trespassing by the legislature in regards to the way in which judges can carry out their function. So the powers of the judiciary and the powers of the legislative should always remain separate and should never intersect. Therefore, apart from the fact that this bill will strengthen the autonomy of the judiciary, it will also reaffirm the notion that the judiciary and the legislative should never run or intersect, that they should always remain separate, thereby reinforcing the doctrine of the separation of powers and restoring the balance to the arms that operate in this country. The Constitutional Amendment Bill 2018, that will redefine the protection that currently exists to the existing laws, the savings clause that I mentioned earlier. By redefining the definition, it would now have in force that the existing laws will continue to be enforced, but will be interpreted to be brought into conformity with the fundamental rights and freedoms of the individuals. So it's changing from the current definition within the Constitution, which states that the existing laws, if they were prior to 1966 and continue before, those laws cannot contravene the fundamental rights and freedoms. The redefinition of the savings clause now would allow for any existing laws to be interpreted in conformity with the fundamental rights and freedoms, thereby continuing to uphold the fundamental rights and freedoms of the people of Barbados. Comrades, honorable senators, honorable senators, it is no easy task here which we have to deal with, because as Senator Caswell stated, he has his reservations regarding the death penalty. But we are not here to discuss the death penalty. We are here simply to look at the mandatory imposition of it. And that is why I support this bill, because these amendment bills clearly show that our government is prepared to listen to the highest court in the land, listen to all of the international conventions that we are assigned to, and recognize that human rights must always be at the forefront of any decision made by the government. And that is all this amendment bill seeks to do, bring our country into conformity with international standards. And on that premise, I support this bill. I'm obliged.
Thank you, Senator Sands. Scholarly. Senator Drakes.
Good afternoon. I want to first thank Senator Sands for that lesson. I am by no means acquainted with the intricacies of the judicial system and the rules that bind it. And I try to keep away from that side of the law. But I thought it pertinent to lend my voice to this debate this afternoon, because as rightly so, we're not just talking about capital punishment and the sentencing of persons, but there clearly needs to be a more comprehensive debate about judicial reform and judicial review in Barbados. We have heard that the trend internationally and regionally is to move away from capital punishment as a sentence for murder, and Barbados being a signatory to multilateral organizations and to the CCJ, I think we now must engage in a discussion that asks the question, where does globalization start? Globalization and regionalism, where does it start and where does it end? Because sometimes it seems as though it infringes on national sovereignty. And we've been seeing a bit of pushback on those types of social constructs when we look at the presidential election of 2016 And when we look at the occurrence of Brexit, when England sought to move away from the EU because they believed that persons within a room were making decisions for them without consultation with them. So therefore, we're asking the question, are sovereign rights and entitlements essentially being eroded and overruled by international and regional standards and laws? And that is nothing against us having international cooperation where we seek to enhance our economic prosperity, we engage in knowledge sharing with our partners and associates abroad. But topics clearly such as capital punishment and how offenses such as murder are dealt with are still clearly grounded in national interests. I would also like to say I was a little concerned when I read the clause 2 of the Offences Against Persons Bill, but the Leader of Government Business in his opening remarks quickly relieved me of my anxiety because the clause in its explanatory memorandum states that the Cabinet has made it clear that the death penalty should be retained as a punishment for the offense of murder. And Senator Walker in his opening remarks stated that the issue of capital punishment is something that the government, if we are going to have a discussion about it, that should be done in a referendum. And that is a position that I wholeheartedly agree with. What I'm also hearing coming out of the debate is the issue of one being sentenced because you are charged with murder, but I'm not hearing the debate on the charge itself, because in the United States, and I stand corrected because as I started by saying I'm not in the legal profession, but in the United States, they have varying degrees of murder, which you can be charged with based on the circumstances. And I'm wondering if that is a step that we can possibly take in the future so that we don't have this conflicting argument of if you're charged with murder, but your sentence is based on specific evidence that is placed for the offense. And I say that because now we're identifying various circumstances in Clause 2, subsection 2, by which death is appropriate. So if we have to look at the various categories by which one can be charged with and then convicted of the offense of murder based on the evidence that would clearly be available at the time of the person being charged. Mr. Deputy President, I'd also like to state that the offense of murder does not just happen between the victim and the person who is accused of the crime, but it also happens to the immediate family, and it happens to us as a community and a society. These acts are not done in isolation. We live among these persons which are being accused, are being sentenced. And I just want to read a quote to the chamber that Martin Luther King gave for the eulogy for the young victims of the 16th Street Baptist Church bombing, which occurred in 1963. And he stated in the eulogy that they say to us that we must be concerned not merely about who murdered them, but about the system and the way of life, the philosophy which produced the murderers. He said that in 1963 in Alabama, and I think that that quote can also be applied to us, here in 2018 in Barbados, where we ask, what type of society are we cultivating that is producing persons who resort to this type of violence? And I ask that on the backdrop of, as was noted earlier in other contributions, we seem to have an increase in gun violence, and more particularly a somewhat idleness and callousness towards the use of automatic weapons on our streets. And we have to then take the mirror and look at ourselves and ask these questions of what are we doing wrong that we are producing young persons in this country and older persons who find it fit and right to use these types of weapons on our streets. Sir, I'd also like to note that the cost of housing an inmate is approximately $30,000 a year. And the Barbados Prison Service 2016 report noted that, but at the end of December 2016, there were approximately 919 offenders. With that type of cost to taxpayers, we now cannot just simply say, lock them up and throw away the key. Given our fiscal constraints, I think it would be wise of us to look at serious judicial review and reform. But on the other side of this, I also want to say that persons who have committed offenses and who have served their time somehow cannot seem to assimilate back into society and become productive persons amongst us. It seems to be a stigma that is attached to them where there seems to be a culture of repeat offenses. And I'll get to those statistics as well. But what I would also like to commend the government on is moving in a direction where there's a more holistic approach to sentences of persons, where we're including now the necessary psychiatric evaluation of accused persons in Clause 2 of the Criminal Procedures Act. Because despite making lots of strides in addressing mental health in Barbados, I do not think we have made the mark in terms of officially and formally addressing it as a society. As I noted, it costs us approximately $30,000 to house an inmate, so that's approximately $30 million a year that we're spending at the prison. And as I noted, the report states that the top 3 offenses were drugs, burglary, and manslaughter. And at the time, 22 males were incarcerated for murder. And the report also noted that 113 persons on remand were for murder, and that represented 23% of persons on remand. It also states that the longest offender at the time had been on remand for 10 years. So that means taxpayers would have spent today, if that person is still there, about $360,000 housing some person who has yet to have their day in court. I think that that is both an injustice to the accused and to our society and the citizens of this country. As I noted, we clearly also have a problem with repeat offenders, and if we look at the amount of money that we're also spending at the probation department in relation to the prison, that also gives a telling story. The probation department is only given $1.5 million a year. And if we're looking at it from the perspective of rehabilitation, then more resources would obviously have to be channeled in the direction of probation services. Mr. Deputy President, in the report it stated that 221 repeat offenders of the 385 convicted offenders were persons incarcerated at the prison in 2016. So we incarcerated 385 persons, and of those persons, 221 were repeat offenders. 57.4%. So persons going to prison, half of them, or a little over than half of them, have already been convicted persons. What I would have liked to seen in that report was possibly a cross-tabulation of the offenses being made so that we can see the joint frequency between offenses. Because if we can look at, or we are aware of the offense the first time, and you have a high probability of being convicted again based on the offense that you're making the first time, we can then start to make greater interventions as it relates to rehabilitation and probation services when you commit the offense the first time. Sir, an effective justice system is one that, for all intents and purposes, interprets and applies the law fairly, it is said, and impartially, and I believe this is where we fall down, without undue delay. And it is seen as a fundamental right of citizens and a fundamental part of a well-functioning economy. I did some research, and what I also looked at was, what are the most peaceful places to live across the world? The Global Peace Index for 2018 noted that Iceland, New Zealand, Austria, Portugal, and Denmark are some of the most peaceful countries to live in. What I found interesting was that 3 of those 5 countries are those of models which have economic prosperity. Iceland has the 25th highest GDP per capita in the world. New Zealand is the highest ranking country for doing business, and Denmark follows them, being the 3rd highest country to doing business. So, in my humble opinion, I think that there may be some link between economic prosperity and a society that benefits from low crime, amongst other things like social value systems, of course. So, in that vein, I say a broken justice system that is non-transparent, coupled with lengthy delays, is clearly then a bedrock for corruption. Senator Franklin went into some examples where there are questionable endings to a lot of cases that come before the courts in Barbados, where too many times we hear of cases being dismissed because evidence can no longer be found or files have simply gone missing. Any society that has the remnants, even the remnants of corruption, is then likely to have a judicial system that facilitates or at best turns a blind eye to that corruption. And the backlog of cases in our court system, Mr. Deputy President, is clearly truly unacceptable, given what I've just said. I know that the government has made a first step in hiring 3 judges to address the backlog, and I commend them for that. But I really hope that that is a first step towards a national integrity system where the judicial pillar is only one step in the process, and that we then have a systematic procedure to address governance deficits, corruption, and dysfunctional aspects of public institutions. So all that I've said, I just want to make it clear to the chamber is that we really have to have a deeper conversation about how we as Barbadians see justice, how we administer it, along with enforcement of penalties such as fines, community service, curfews, restorative and rehabilitative programs should be discussed openly and frankly. Also, part of that conversation, given the nature of what we're dealing with today, I think it is only right and fitting that we also talk about national and individual consciousness. If we're talking about persons we are sentencing for murder, it is also a psychological aspect to it that we cannot lend to something that is not important in the discussion. And it also begs to ask the question, how do we as people relate to each other and the health of our relationships? So, with those few words, Mr. Deputy President, I will end how I started, where I strongly believe that the rights of a people, of a nation, to determine whether or not capital punishment remains on the statute books should be something that is done through referendum, and that we as legislators should also always remember that our first constituents are Barbadians, not the international community, and not regional organizations. And giving the public the right information to make informed decisions on matters such as this is the way in which we should address these matters. So, Mr. Deputy President, with those few words, I'm obliged to you.
Thank you, Senator Drix. I recognize Senator Haynes. This may very well be our last speech before we take the break for lunch. Senator Haynes.
Good morning, colleagues. I rise this morning to lend my voice. Good afternoon, colleagues. I rise this afternoon to lend my voice in support of these amendments. So there's been an unofficial moratorium on the death penalty in Barbados for the last 34 years. But we still seem to have this very emotive or emotional response every time the words death penalty come up. I remember looking at the headlines of the leading newspaper on the day after this was debated in the other place, and I saw a headline, "Let them hang," words attributed to the leader of the opposition. I watched the debates from the other place, and one of the other references that was made repeatedly was a scripture reference to an eye for an eye. I actually bought a Bible and I went looking. So this verse is found in Exodus chapter 21. And I took the time and I went through the entire chapter. And what I found was so interesting. I saw in verse 17, it said, if a child curses their parent, if you curse your parent, you should be sentenced to death. I saw one that said that if, I think it's verse 20, said that a slave master could beat a slave within an inch of their life. And if these slaves survive, the slave master should not be punished because the slave is property. So I just found it amusing, having discovered that context, that people in the wider society are still using an eye for an eye as a point of reference. The reality is, though, that we've seen a number of crimes over the years, tragedies that you can't help but feel away. Senator Franklin referenced one of the cases, which was that of a school-aged girl being killed by some person who was trying to basically get retribution for something that happened between him and his employer. And that was one case that I remember feeling very, very strongly about. But what we in this chamber have to remember today is that these amendments are not about our personal views and how we feel some person who perpetrates a criminal act should be handled, because that's not our place. That is the place of the judiciary. So we're here because, as it stands, the Offenses Against the Persons Act says that a person who is found guilty of murder shall be sentenced to death. And one of the things I've learned in my time here is that every letter of the law has a meaning. We in this chamber, those in the other place, cannot dictate to a judge what they should be doing. So one of the terms that we have heard repeatedly is rubber stamping. And as it stands, what is happening is that because we haven't given the judges the discretion to make a decision, we're prescribing a sentence and telling them that they have to do it. And I believe that that is what lay at what founded the basis of the decision of the Caribbean Court of Justice when they ruled in June. So I know that there was some statements made about the Caribbean Court of Justice and so on, but I would like to vouch for the fact that we as a country who have seen 52 years of independence could say that we have our highest court of appeal based in the region, formed by justices who have lived and experienced life in the region. Their context, their understanding of issues that people in the region experience, I think, would help to formulate their rulings in a way that I believe would be more sensible and more relevant than a ruling being handed down by the Privy Council. One of the other things that is important about the CCJ, I understand that having appeals handled by the Privy Council happen to be very, very expensive. Some of the other things that the CCJ has managed to do as well is that I'm aware that the case in June, there had like some kind of electronic hearing. Like, yes, you don't have to submit. They're supposed, wasn't it, could you watch it on video? As I recall, that was what happened. So we're actually seeing a more progressive way of handling the affairs of the court and the cases through the system. So I know Senator Franklin put some licks in them, but even though four countries have come on board and Antigua and Grenada have made their decision, I stand by the decision that our country has made, and the fact that in the last 13 years they have represented us well, even leading into elections with the decision that they made on the right of the Commonwealth nationals to be able to vote in the election. So I know Senator Sands and others would have spoken quite extensively on the particulars about the American Court of Human Rights and so on. I'm not an attorney, I'm not going to venture into those waters, but what I would like to speak to as well are some of the social issues that surround any discussion that we should be having on an issue such as this. So one of the statements that Senator Franklin had made as well, I think, was that the government was being soft on crime. He said that it would appear that we were being soft on crime. Okay. But one of the things that we can all remember is the recent spate of crime in the north of the country, where we would have seen a spate of gun and gang-related violence and retaliations and so on. And we saw the swift action actually of the Royal Barbados Police Force, where they literally locked down the north, and they did what they had to do. They searched homes and they found 4 persons who were wanted in connection with serious criminal matters. I think that is actually taking a tough stance on crime. One of the moves that we were also able to accomplish very, very early on in the administration, as Senator Drakes would have pointed out, is dealing with the backlog of criminal cases. So my research had led me to the fact that there are about 950 cases awaiting trial. And that 42% of the prison population are persons who are on remand, who are still awaiting having their cases heard. So the appointment of those 3 temporary judges is a move in the right direction. The Chief Justice as well, I understand, would have overseen a course held by the jurist, I think it's called the Jurist Project, which had trained over 40 mediators. And the whole aim of that project was to have matters, if they could be settled out of court, handled by these trained mediators. And that project actually, I believe, was also birthed out of the Caribbean Court of Justice. So they have to be commended for that as well. Now, I want to speak about a few other things, including education. So we have a situation where the United Nations Office on Drugs and Crime reports that there is a direct correlation between low educational attainment and a person's likelihood of perpetrating a violent act, including murder. So I found some stats on our secondary schools' performance rates. One of the statistics that I found shocking was that 28.14% of students are leaving secondary schools, and this is a regional statistic, not Barbados specifically, but 28.14% of secondary school students are leaving school without a single CXC pass. 21% of students are leaving schools without having, only 21% of students are leaving school haven't met the basic requirements for matriculation, which is 5 CXC passes. I don't believe that is a very, very high bar. But if you only have about 21% of children leaving school even being able to pursue or being able to be accepted to university, we really have to look at reforms on the front end rather than constantly spending on the punitive end. So one of the things that I was very happy about was the reinstatement of tuition fees for the UWI. One of the figures I came across was that there was a decline in enrollment by about 57%. These figures were attributed to the principal of the Cayfield campus. And what she indicated was that 57% of students who had been accepted were not able to enroll. And at the time when the former administration had the policy in place where tuition wasn't being covered, they made the point of calling each of these households individually to find out why they weren't enrolling. And in most cases, financial hardship was cited. So to be able to have a situation where that 57% can now say, you know what, I had a dream of becoming an economist one day. I had a dream of becoming a physician one day. They'll be able to do that. The other thing I wanted to address was the situation that we're seeing on the blocks. So blocks largely are seen as kind of a hive for criminal activity. And I think that to a certain extent, not all blocks are the same, and not all can be fairly labeled as such. I personally know someone who was expelled from 2 different secondary schools, found themselves on a block, and they had a turning point in their life. And 7 years later, that person now holds an honors degree in economics. So these young people, many of them for different reasons, it could be issues related to their families, it could be related to failures in the school system. For some reason, they were failed by society, and we can't give up on them. They're people who may have intellectual gifts or other talents who, given the correct mentorship, who, given the correct training, may be able to change their lives. So one of the programs that I'm aware that the Minister of Youth Empowerment has brought on stream is that of the Building Blocks program. And what he is attempting to do is to pair these young men on the blocks with positive role models and mentors who can coach them, who can train them, who can help them to become more self-sufficient and self-sustaining, who can help them to gain respect through legal means rather than feeling like they have to gain respect through whatever is dictated by the gang leader. And these are all moves in the right direction. In closing, because I don't have a lot to say on this matter, but in closing, there's one other thing that I wanted to speak to on a personal note, And that is with regards to some of the work that I've been exposed to through the Sir Optimus International Organization. They have adopted the government industrial schools, and I've had the opportunity to visit on certain Saturdays with them. They're doing very, very good work, but right now the government industrial schools actually falls under the Ministry of Home Affairs. And we have to remember that these are still school-age children, and I would like to see them have greater access to training and formal education so that they too can be better able to reintegrate to society when they have completed their time there. So with those few words, I'm obliged.
Thank you, Senator Haynes.
Mr. President, I beg to move that this sitting be now suspended for lunch until 2:30 p.m.
The question is that we do not now suspend for lunch until 2:30. Honourable senators in favor, please say aye. Aye. Those against, ayes have it. Suspended until 2:30.